Hi, good morning, guys. Wherever you are that is watching us this morning, we are here, three of us, three friends, here to have a chit-chat forum. Why we gather here today? Because of course, the COVID crisis currently is impacting us and the country and the world actually. And also because of the partially lockdown situation, the MCO order in Malaysia right now. And few days ago, Bank Negara also made some announcement on a moratorium repayment for SME as well as individuals. And yesterday, Malaysia Prime Minister also announced another Caring for Rakyat stimulus program. So with so many things happening all at one go, so I thought we just gather a few friends to have a chit-chat sessions. And in case you do not know who I am, my name is Elizaberth Siew. I used to be a property lawyer for many years and ventured into property technology and legal technology currently and going into digitization. And also I'm the secretary for a koperasi called Koperasi Pengurusan Hartanah Malaysia. We have a lot of members where we help them to also manage our properties and so on. Now then I have a good friend here, Amenny Chua, who is the founder and managing partner of One World Realty Group, all right? And also, she is a seasoned real estate practitioner and also investors, right? And also we have a corporate commercial lawyer here, kiew, right? Who is the founding partner of Amidst kiew, right? Okay. We work a lot with Kelvin in terms of contracts, and also some real estate related contract and developer related some matter, right? So yes, hi guys, say hi.
Hi, morning.
Hello, good morning everyone.
Good morning, everyone. Hope you are doing well at home.
Yes, correct. We are like partially casual talk and partially also I think we want to discuss really not the policy, but how the policy is really affecting people, and I mean the real reality of it now. What is really happening to people, and how we want to deal with these real issues on the ground. Maybe okay. I just start first because being a secretary to a koperasi, we actually have a lot of properties where we manage for the members, and we collect rental for members, and we manage some of their funds, so to speak. And after the Bank Negara announcement of the 6-month moratorium period, there were a lot of confusion. But we already started to have tenants calling up koperasi to not ask for rental-free period, to ask for a lot of freebies from us as a koperasi. So the president and the secretariat they were actually busy, dealing with all these issues at the moment. So Amenny, I understand you also are facing some of these phone calls, right?
Yeah, I said, I mean, maybe we just back to before the MCO. Okay, so before the MCO, in fact, there's a lot of negative informations already spread around. And I think first thing first, a lot of business owner, especially those running the SME, their concern is either should I close my business now, or should I still carry on? Because if I close my business now, then I would be not able to pay the staff salary, the rental, and so on. That is actually on the on the business owner side. But same thing actually goes to a lot of the tenants that during this lockdown period, this MCO period. So then the company actually probably need to plan for the cash flow. Then they start up with a lot of issues like how could I pay my rental? All right. So then therefore a lot of the agent actually call to the company to ask for help, because in between the period the sales, I mean the rental is still carrying on, right? So then we receive many tenants start to call the property agent. The first contact will be property agent. All right. So then how could I get the help from the landlord by not paying the rental? All right, so this is some of the cases happens lah. All right, should I pay or should I not paying? And there will be two different parts. One is a residential, and the other one is the commercial. Yeah.
Mm-hmm. Right. Okay. Okay. So what about Kevin? Your side, I heard you also receive a lot of calls. Last.
We receive a call from tenant and also landlord. So most of the tenant either they request for a waiver during the MCO or suspension, right, or even termination. They want to walk out from the tenancy because they will foresee that
I see.
Back, in the future 6 months or the upcoming months. Yeah.
Right.
So there are different requests from tenants.
Mm-hmm.
Some of them they ask for waiver. Some of them ask for suspension. Suspension means they only suspend the payment of rental for these 28 days during MCO.
Mm-hmm.
And then thereafter, they must pay back to the landlord the rental for the 28 days. It's only suspension, like deferment.
Mm-hmm. Okay. Oh, so it's like deferment. So it's like what? That means like if a 2-year period, so now it becomes 2 years plus 6 months.
Yeah, meaning to say after the expiry of the tenancy, they must still pay rental for the 28 days.
Oh, okay, okay, all right.
All right. Okay, maybe I have some cases that I would like to ask Kelvin. Okay, so I mean from the legal part, actually, how do you advise the landlord or the tenants on this part? Okay, there's one case that actually raised by my agent. All right, tenancy to expire on 31st of March, and tenant wish to move out, vacate the condo, but somehow the mover can't facilitate their job during the MCO. Therefore, the landlord still insisting that the rental must be served by the tenant who happens to still this staff is still actually in the condos itself.
Okay, this question doesn't really involve a lot of principle of law, so I think I can explain this question by the facts of the case. So as the obligation of the tenant, when tenancy term expired, the tenant obligation is to re-deliver vacant possession of the property back to the landlord. The meaning of delivering vacant possession, not only you move out physically in person, but also your goods and belongings. So even though you have moved out, but your goods and belongings still remain in the premise, meaning to say you have yet to re-deliver vacant possession back to the landlord. Right? So looking at it, the tenant will still have to continue to pay the rental to the landlord.
And Kevin, now we are actually now a lot of lawyers are looking at the claim for force majeure, all right, and frustration. Okay, like force majeure is like act of God. Okay, beyond the control of the parties, right? Can the landlord or rather the tenant, can the tenant now rely on this to claim that there's force majeure?
You mean moving out the belonging and goods from the premises?
So to perform because his duty now is to vacate the premise. So he's unable to do that. Yeah.
Okay, when we talk about this performance of the tenant under this situation, i.e. to move out the belongings and the goods okay, if you want to claim for force majeure, then you have to ensure that such force majeure event is stipulated in the agreement.
The clause must be there.
Yeah, must be expressly spelled out in the agreement. And then also you have to ensure that this outbreak or this MCO is one of the force majeure events.
Okay. Because force majeure is very specific, right? You need to spell out.
Yeah, some will argue that this is not an act of God, but rather outbreak or pandemic. So whether outbreak or pandemic disease outbreak is considered as an act of God.
Correct, yeah.
So we have to argue the definition of act of God, unless it's specifically spelled out that force majeure event includes a pandemic disease outbreak or act of government.
But unfortunately, in Malaysia, in Malaysia, most of the tenancy agreement is quite simple, in Malaysia, especially normal residential and normal commercial. It's very simple. Unless you're talking about tenancy that is dealing with really like big corporates or shopping mall, then they have extensive tenancy agreement. Otherwise, we normally don't see force majeure clause in tenancy agreement.
Yeah, agree. I think in most tenancy agreement, even lawyers as well, most of the lawyers, they just take force majeure clause as a pinch of salt, right? So they don't really focus in force majeure clause. And also these are the unprecedented disease outbreak and MCO. So a lot of lawyers, they don't really focus in force majeure clause. So that's why a lot of the force majeure clause in tenancy agreement is not watertight. It doesn't cover this, for example, MCO.
Okay. So in this case, in fact, we are just, liaise with the landlord by just telling them this is something that no one actually wanted it to happen. And it's actually, we can't actually really go into the contract at this moment. So what we did is we are talking to the owner to give them a relaxed time. After the MCO, then only they move out. So do you think that actually this is a good advice to the landlord?
Okay. If,
from
right. Let's say the tenant want to rely on force majeure clause, the threshold is very high for them to prove. Because most of the time, force majeure clause, the consequences or the remedy is that you will have to terminate the agreement. But now most of the tenant is not requesting for termination. Rather, they're requesting for waiver or they're requesting for suspension, right? Unless the force majeure clause specifically states that under these circumstances, you can suspend the payment or you can ask for waiver as of right. Other than that, most of the force majeure clause, if anything takes place, then it's only termination that's the only remedy.
So conclusion is if based on the tenancy, I think the tenant, if the tenant cannot move out or move out of the premise and re-deliver vacant possession, then the tenant will have to pay rental for that additional period.
Yeah, because if we are talking about tenant unable to arrange for or facilitate logistics to move out the belongings or the goods, that doesn't mean impossible or unlawful. Because some of the logistic companies, they still provide logistics service. Because it's logistics service categorized as essential business under the regulation for MCO. So it's only practical, but not impossible or unlawful.
Correct. Okay, all right. So okay, looks like this is up to the tenant and the landlord to have a friendly talk, outside of the contract. If they agree, then it's good lah. Otherwise, I think actually, Amenny, okay. Yes. Now looking from the practical viewpoint now, if the tenant only move out after the expiry, so the 2-week rental is actually not much, So, and the only thing is I foresee the landlord will deduct it from the security deposit.
Yeah, yes.
And then they will in a way forcefully deduct it, and then they will return the balance of the security deposit to the tenant. But because the quantum of the 2 weeks is small, maybe 1,000, 2,000, you won't go to court for it.
Yeah.
Right? You won't go to court. So end up, it's just like they're calling each other. But I think there's nothing much the tenant can do, in practical sense.
Yeah, I think so.
Yeah, correct. So okay, never mind. So you have more scenarios, right?
Yeah. Okay. The second scenario is the tenancy term start on 1st of April. All right. And the tenant requests to extend the commencement due to the MCO because it's supposed to be usually when we talk about the rental it will be having a great period before the start. So during the signing of the letter offer and also the tenancy agreement is actually way before the MCO start. So now the landlord are arguing that they already signed the offer letter. So then why they wanted to request for the extension of moving in later. All right. So in this part, so how usually we, because it didn't happen before lah, okay? So now this is a time that actually a lot of our agent is actually facing this difficulty, how to overcome the obstacle that letter offer sign, but yet the both party argue.
Have they signed tenancy agreement?
Yes, they signed already. Tenancy agreement signed. Commencement of tenancy is supposed to be 1st of April. But now, due to this MCO, in fact, the tenants is actually giving of course, it's a valid reason. They cannot move at this moment.
Okay, commencement just now, Amenny mentioned is on 1st of April, supposed to be on 1st of April.
Yes.
So, what the landlord will have to ensure that prior or on the commencement date, they will have to deliver vacant possession of the demised premises to the tenant. So, as long as the landlord is able to deliver vacant possession of the demised premises to the tenant, so technically the commencement will kick in, notwithstanding that the MCO is in place. Right, and then we will talk about rent-free. It's more like a courtesy and a goodwill offering to the tenant.
Agree, yes.
Landlord will not have to make sure that you are in a position to carry out whatever renovation or to move in your belongings to the premises. Because rent-free is a courtesy offering to the tenant.
So it is not as of right. It is not.
Rent-free is not as of right, because some tenancy, it doesn't come with a rent-free period.
Yeah, correct. Okay.
All right.
So I think this is the same argument as the first scenario lah. So it is so yeah. So you have one case, they cannot move out. You have another case, cannot move in.
Yeah.
All right. Yeah. Wow. Okay. So okay. So I think contractually we can conclude lah. Contractually, they must follow the terms in the tenancy agreement lah. So now if also okay, maybe Kelvin, since you're here, we want to discuss with you another subject matter, which is the duty of the agent, right? Maybe also Amenny. So I notice now the landlord and tenant are they keep calling the agent, but based on your based on your guideline as well as your act, actually agent's duty, does it cover this?
Okay, based on the role of the agents in the whole rent and sales situation, in fact, our duty is end upon signing the tenancy agreement or the SPA. All right, but in view-wise, so we will still doing the follow-up and also the after-sales service with the client. So this is the part, but a lot of tenants, they always wanted additional value-added service. So the first thing first, the first touch, they will still call back the agent. Yeah, so that also makes a lot of agents quite in a very difficult situation as well.
Right, yeah. But unless the agent also does additional work in terms of managing the tenant for the landlord, there are some agents.
Unless the landlord appointing the agent on the property, we call it tenants management. Otherwise, our service is actually end on the after signing the tenancy or the SPA.
Right. Because I do receive a call 2 days ago from a friend who is a property, who is a tenant management company. One of their duty is to collect rental. So now they cannot collect rental, and the landlord is chasing them. When this company they are trying to be the mediator in the middle between landlord and tenant, and try to get them to go on like a 50-50 situation, give and take situation. But the landlord turn around and say that is your problem as a tenant management company. It's not my problem. So I think maybe some of the agent who is also double up doing tenant management, I think they will face the same situation. And the next thing that will trigger off is that if you cannot collect rental, I do not pay you service charge. Do you foresee this problem?
You talk about service fee of a property manager. In order for you to charge your service fee, you have to deliver your performance, i.e. collection of rental, tenant management. But if let's say you fail to collect the rental, meaning to say you didn't fulfill the condition or deliver the...
Okay, right. So, wow, looks like a lot of this kind of like a checkmate situation. Okay, but okay. Anyway, moving on. Amenny, you have a lot of other scenarios. Looks like. Can you share with us?
I have another scenario. It's actually a shop. All right. So it's a commercial property. The shop lot is actually at Bukit Jalil. All right. So it's also about the rent-free period at the moment. So this property, before the tenant decide to accept the offer, so there's a rent-free period for the owners for the tenants to fit out the properties. But somehow, during this MCO, the tenants are not able to do the fit out. So then they request the owner to grant the extension of the period. So while waiting for the renovation can be carried out. So this property is still not going into the tenancy agreement yet. It's supposed to sign the tenancy about 23rd of March, but somehow now the landlord want to forfeit the deposit due to the tenancy agreement cannot sign.
Okay, if let's say the landlord will want to forfeit the deposit based on the reason that the tenant refused or unable to sign the tenancy agreement, then we can actually raise the defense of I'm unable to sign given that of this MCO. My movement is restricted unless lawyers can go to their house and let them to sign the agreement. Otherwise, it will be impossible for them to attend to the execution of the agreement.
I think during this period, a lot of lawyers is also same thing that we can't actually go out, right?
Because lawyers' movement are restricted as well. We can't operate our law firm. We are not essential services.
So then in this case, the conclusion is that the landlord, that means the non-execution of the tenancy agreement is due to event that is beyond the control of the parties. That means the tenant wants to sign, but unable to sign.
Some of the time, there's this clause mentioning about signing in counterparts. But still, if let's say I do not have a printer at home, so how do I sign in counterparts? So probably we can look at signing.
But can they actually use the e-signing kind of the services probably already very widely used in the overseas?
Yeah, actually in Malaysia, in fact, actually one of my company, we are actually doing e-contract and e-signing. So actually during this period of time, a lot of our own documents, we actually e-sign it. We even sales and purchase agreement in order to fulfill the deadline imposed by developers, we actually e-sign as well. So when we go to, I don't know whether when we go to court, at the end of the day, as a landlord, can I say that it's not impossible for you to sign? Because when you go online, there are so many software, for you to upload your tenancy agreement and you can e-sign it. So maybe there could be another argument, from the perspective of the landlord, if the landlord is trying to forfeit the deposit, right? So that could be one argument.
I think that's the contentious point as well. Because when we talk about impossible, meaning to say there's no other avenue for the tenant to sign. But we mentioned about e-sign, definitely is one of the options.
Yes, yeah. So a lot of this eventually, if it goes to court, I think a lot of both sides has got their own argument. Yeah. But of course, from the practical point of view, Amenny, think from the perspective of a landlord. If they forfeit the deposit, they let go of the tenant. How soon can they find another tenant? It's also not easy.
Yeah, this is the part that actually we also advise the owner, especially during this tough time. In fact, we probably need to keep the tenants by building a good rapport, and hopefully that actually once the MCO release, then the tenant can straight away start the tenancy agreement instead of we just take some time to find a new tenants for them. Yeah, so this is some of the thing that actually we advise the landlord at the moment.
Yeah, because it seems like not the tenant who refused to sign, just that given that during this MCO, so it's not practical to actually sign and enter into the tenancy agreement.
Right. Okay. So now, Amenny, you have other scenarios also, right? I think you were discussing. Any other interesting thing that happened among your agent?
I think mostly is about the tenants actually request for the rental reductions due to the moratoriums, that announcement and so on. I think this is the part that a lot of landlord is actually refusing of giving these facilities, but somehow tenant actually is requested. Yeah, so in this part, I think is one of the very important key for the real estate agent. How can they during this time to advise the landlord and the tenants on the whole tough time.
Right, it's true. It's true because after the announcement by Bank Negara, actually Bank Negara issued a letter to all the banks. Then the following day, Bank Negara make the press release on the moratorium period, and immediately the reaction from most of the tenants is that in their mindset is that, oh, automatically my rental also no need to pay because my landlord doesn't have to pay installment, right? So that is automatically in their mind, right? Then to the landlord side, when we really study all the banks' circular now, interest is, even though there's a moratorium period 6 months, but the bank will still charge you interest. The bank will not charge compounding interest only, meaning interest running, but no interest on interest. So there's still interest element, and the interest element is like going to what they call that, be accrued. So as a property owner, I still have to pay interest at the end of the day, so at the end. Whereas a tenant, they come in, they stay 2 years, then that's it, they leave, So that additional burden comes to the landlord, which the tenant is not going to bear. So that is landlord's perspective. Also the perspective of koperasi, we also have this problem.
Okay, so I think another one that actually I want to bring out is about the foreigner that the tenancy agreement with the fixed cross agreement. During the the last 2-3 months, in fact, this is actually mostly on the China tenants that who already rent the property, okay, before that. But due to this lockdown in China, so in fact, a lot of their employees now come back. All right. So for the fixed cross agreement, usually it's like you need to fulfill the 1 year or the 2 years contract you sign. Okay. In this situation, how do we handle?
It's also actually in reality it will happen. Actually, it's fixed cross. Fixed term means they have to compensate the full term.
Yes, right. So then, all right. So Kelvin, there's another scenario here. There's a fixed cross agreement for the foreigner that who rent the property before the COVID-19 happened in January. All right. So then basically during that period of the lockdown in China, and many of them couldn't come back to work until now. All right. But in the fixed cross agreement, they cannot just terminate the agreement like that. They need to do the compensation to the owner of the let's say tenancy is actually 1 year. So then the remaining of the month that actually which they are not using, but they still need to pay the rental.
Right.
Yeah.
Wow. Okay. Looks like, yeah. Actually, this is again another situation that is bound to happen. Now, correct? Because foreigners are not allowed to enter some countries. It's like that. They even forbid, like Singapore. Foreigner cannot enter Singapore. Only Singaporean can come back. So Malaysia, we have not started this restriction. But of course, China also they will not be able to come out. So fixed term tenancy is actually quite a issue leh. So Kevin, what do you think? Fixed term agreement.
Unfortunately, generally in tenancy agreement, there's no special treatment in the capacity as a local or foreigner, unless that's specifically mentioned in the agreement of such a scenario where they can terminate.
Yeah.
But
So
usually in our agreement, there's no cross.
Okay, so all right. So I think let me take 5 minutes to explain about the principle of law that will be applicable for all the tenancy across generally. All right. So in the event the tenant will want to terminate the tenancy agreement, like Amenny mentioned about the foreigner. All right. Firstly, we have to look into the contract or the tenancy agreement, whether is there a clause for force majeure event, right? First, we would if let's say in the event there is such a clause in the agreement, then we have to look into termination for force majeure event, whether this outbreak of COVID-19 is categorized as an event for force majeure, right? So force majeure meaning to say an event which is beyond the control of the parties, which render either parties are unable or impossible to fulfill their obligation. For landlord, the obligation is to ensure that you have the peaceful enjoyment of the demise premises. Whereas on the other hand, for the tenant, the performance is to pay rental. So for landlord, definitely it's not an issue for them to perform their duty, right? Because you're already in possession of the property. And notwithstanding that of this COVID-19, you still can enjoy the peaceful enjoyment of the demise premises. Even if you are in China, your personal belongings or goods are still in the demise premises, right? So having said that, payment of rental, whether is it impossible to perform, we can actually do the online transfer. So it's no exception if, let's say, you are a foreigner to enter into tenancy agreement for property in Malaysia.
Okay,
right?
so now besides the force majeure clause, because force majeure clause must be spelled out in the tenancy agreement. So many tenancy agreement in Malaysia does not have force majeure clause, so they cannot rely on it. Then on the other hand, the principle of frustration, can the tenant claim, the tenancy has been frustrated, they cannot perform. What do you think about that?
Okay, that's a very good point about this doctrine of frustration. If let's say there's no force majeure clause in the contract, then we would then look into the doctrine of frustration. So this doctrine of frustration is provided under Contract Act, particularly through Section 57, right? So this particular section actually refers to frustration as an event which become impossible or unlawful to act after the parties enter into this contract. So if we talk about if tenant want to raise frustration, then they will need to show that it's impossible or unlawful for them to perform the obligation, i.e. payment of rental.
I see. Okay. So looks like if strictly following law of contract, and so on, tenant, the moment they sign a tenancy agreement, they will have to fulfill the terms of the tenancy agreement. So it's up to the goodwill of the landlord to maybe to vary the terms of the tenancy.
It's subject to the future agreement between the mutual agreement between the parties. Because most of the tenant, they raise that they do not have income. Okay, Or sometimes they will raise is specifically stated in the tenancy, usage of the demise premises for F&B purposes. So now I cannot operate a business. So will it affect the usage of the demise premises? So if you interpret strictly here, for say, for example, F&B, it fall under the essential services. You still can operate, right? Just that your customer cannot dine in, but you still can operate.
Okay. So for business that are not categorized as essential businesses, so we will have to argue that they are still occupying the premises as in all their goods and all the furnitures, everything are still inside the premises. Therefore, you still have to pay rent.
Just like, for example, for factory, you cannot operate the factory, right? Because the workers are not allowed to attend to work. But your machineries and equipment are still stored in the factory or the warehouse. So you are still receiving benefits.
I see. Okay, that is a very good point. That's a very good point. Right. So guys, now, so assuming now our landlord and tenant manage to talk to each other and agree on a new term, for example, rental reduced by 30% for 6 months. So this is a separate terms that they have agreed, ma'am. So Kelvin, do you think we have to sign a supplemental tenancy agreement, or how should we deal with this?
Okay, in order for the landlord and tenant to facilitate this arrangement, right, I would advise that they sign a supplemental letter, all right, incorporating that the rental free period or the waiver of the rental, right, so that in the event if the landlord didn't adhere to his or her promises, then at least the tenant can still fall back to this supplemental letter as an evidence that they have promised to waive the rental for, say, the stipulated time.
Okay.
Right. Good.
Wow, okay. Kelvin and Amenny, and also to myself, I think this is a very good discussion, So with all this information overflow that is happening in the country, so at least for us, we managed to really go on the ground and understand from the agency and agent perspective what is really happening on the ground and real case customer, what are their concerns, right? So it's good that we get to discuss. And also thank you to Kelvin for your input as a lawyer, and also sharing with us all the principles of contract, how we can actually rely on the contract for this situation. Okay, so so I think with that, thank you very much, guys. Bye. We see each other again.
Yeah.
Right.
Thank you so much.